On this episode of Insight, does the jury system always get it right? Lindy, you're a household name in Australia because you were wrongfully imprisoned for murder after the disappearance of your daughter Azaria.
I just yelled out, "Has anyone got a torch? The dingo's got my baby."
The murder trial opened in Darwin today with the Crown prosecutor dismissing the dingo theory as a fanciful lie.
The prosecution says that here, Lindy Chamberlain cut the throat of her baby and husband Michael helped cover up the homicide.
Lindy Chamberlain has exhausted all her legal appeal rights. Her only hope is that the Northern Territory government will make a political decision and hold a fresh judicial inquiry.
They have advised me that the discovery of a baby's matinee jacket near the base of Ayers Rock may have a bearing on the case.
Lindy Chamberlain has been released from Darwin jail and she won't be going back.
If the Chamberlains were today charged with murder, it just wouldn't even get off the ground, and it certainly wouldn't even be left to a jury.
Lindy, in 1982 you faced a jury trial that lasted almost 7 weeks. What do you remember about the jurors?
Well, we weren't supposed to even look at them, but you kind of keep an eye out the side and watch them. And it was interesting to see, there was one gentleman in particular in the back row that seemed to be listening to everything and understanding most of it. There were a couple of jurors that more or less sat there with their arms crossed and looked around the room, and it looked like they'd made up their minds. There were others who were uncomfortable, squirming in their seats at various times, occasionally even crying.
Why weren't you supposed to look at the jurors?
For fear that I would influence them some way or another. I don't know whether they thought I was going to try and hypnotise them or...
Was this your first experience with a jury?
No, I sat on two myself before that.
Here's how Australia's jury system came about.
The legal right to be tried by a jury of your peers was a concept that originated in medieval England. Brought to Australia by the British, this system was widely adopted throughout the 19th century. Today, jury trials are mainly used for serious criminal charges. While laws vary by state and territory, in most criminal trials, 12 people are randomly selected, aiming to represent the broader community. Serving as a juror in Australia is mandatory, and anyone enrolled to vote may be chosen. There are some exclusions. For example, those with certain criminal convictions, public officials and lawyers can't serve. Potential jurors must also understand English, and currently those who are deaf or blind can't participate either. Anyone selected can apply to be excused, though they'll need a good reason. The jury's role is to consider evidence and arguments presented in court, after which the group will deliberate to reach a verdict. Historically, all members of a jury had to agree, but new laws now accept a majority verdict in some cases, with the criminal jury ultimately deciding whether a defendant is guilty or not guilty, beyond reasonable doubt.
Anthony, you're a former New South Wales Supreme Court judge. What does beyond reasonable doubt mean?
Well, it's a very commonplace expression. I think I would say it means exactly what it says and nothing more. Countless judges have tried to give it some additional meaning or explain it in terms of percentages to juries, but the superior courts have all said that that's wrong. They shouldn't do that. You simply say to the jury, you have to be satisfied beyond reasonable doubt. Jurors seem to know exactly what that means. Another way of putting it, of course, is to say to the jury, and judges commonly do, If there is any reasonable possibility that a person is not guilty of the crime, then you must acquit them. So that's the reverse way of expressing it.
What is the judge's role in a jury trial?
He has an important role, but he's not the most important person in the court. The important people are the jury, and that's because they decide the facts. The judge is there to tell them what the law is, to rule on evidential matters and to keep control as far as he can in the court, or as far as she can. And then it's up to the jury. They are the main focus of a criminal trial.
Yvonne, you publicly identified yourself as a juror in Lindy's trial. What was the selection process like?
Oh, it was huge. 150 people were called and we all had to go into the court that day. The solicitors would take names out of a hat or something, a bowl, and read your name out. And when your name was called, that person would stand up, make their way, and then the Crown or the prosecution would say yes or no.
How did you feel when you were chosen?
I didn't think I would be chosen. I thought I'd be going home.
Why didn't you think you'd be chosen?
Because probably I wasn't an important person. I don't know. I was just very ordinary.
Anthony, is there a way to choose the most suitable jurors for a trial?
Just to comment on what you had to say, it's very important that ordinary people be part of the jury. The whole jury system is designed to have a random selection of members of the community with as diverse a background as possible. So the question about the best way to select a jury is the challenges, of course, to jury panels are left to counsel for the Crown and counsel for the defence. They have the right to challenge. But in ordinary trials, I think people often have good reason to be excused, so the judges have to be sympathetic to people who, for example, have their own business or are school teachers or who have booked to go overseas on a long trip, as the case may be. They're often excused from attendance. After that, it's really up to counsel to challenge the people they want to challenge. In Australia, of course, we don't name the jurors, or in New South Wales, we don't name the jurors anymore. They're all identified by a number and they remain anonymous, and that's to protect them and to protect the whole system.
Luke, you're a criminal defence lawyer in Victoria. What do you consider when you're selecting jury members?
Well, there's not much that goes into it, really. The last trial that where I picked a jury, it was based on first impressions. When their number was read out, they state their occupation. And really, I exercised 3 challenges, but it was basically based on body language. One was a young tradie who clearly by his demeanour indicated that he didn't want to be there. The trial required, we understood that it was going to go for about 2 weeks and there were some pretty serious issues to contemplate. And I thought, I don't want someone on the jury who doesn't really want to be there and is making it very obvious they don't want to be there. The second one, again, it was body language. And the third was a CEO. She'd come in and she was professionally dressed. And again, the decision to challenge was based on the fact that this is an incredibly busy person. But it was no more than that. There was no in-depth thought about how they could potentially sway a decision or whether they might be against us. I think one of the benefits of the jury system is you've got 12 individuals who are chosen. Individual prejudice tends to be flattened out over that 12.
Crispin, you were admitted as a barrister but have been a journalist for 4 decades and you covered the Chamberlain's Court appeals. What are your thoughts on the jury selection process?
Anyone who's professional, anyone who's got a business to run, all of the sorts of people who might be quite competent as jurors almost self-exclude themselves because they don't want to serve.
You say that after Lindy's case you became anti-jury. Why is that?
I covered the cases and I was really convinced by Ian Barker in the federal court. He was very persuasive. And I have to say, Lindy, I'm sorry. But after I covered these cases, pre-internet, people who didn't like this case and thought something went wrong came to me because my byline was in the paper. I had scientists from the John Curtin School of Medical Research. I had people who were dingo experts, and I was writing these stories. And I thought, something seriously has gone wrong here. This system is a crock.
Lindy, do you think the traditional concept of being tried by a jury of your peers is relevant today?
No, I don't, because most of them may be your peers, but they're not peers of the evidence. Evidence these days is extremely technical for jurors who are just ordinary, as Yvonne said she was, to understand evidence that is way above their heads. They are not peers of the evidence.
Anthony, do members of a jury represent a cross-section of society?
I think, broadly speaking, they do. There are some people who are, in effect, self-excluded, but, you know, we have a broad range and diversity within Australia. We have men and women and whatever else we have, and we have people from every nationality, racial background, ethnic background. They're all eligible, they're all on the electoral roll. I think the answer to that question is yes. I think Lindy's trial was very unique in Australia, and I wouldn't blame the jury system for what happened there myself. I think that if the jury had been properly instructed and if the evidence from experts had been critically analysed and that part of it that was offensive excluded, then I think it could have been quite a different result. Mind you, there was an enormous amount of prejudice against her. The media was against her. There were hardly any stars aligned in her favour at all, and it all came together. There was a very powerful Crown prosecutor and a defence lawyer who was perhaps not as successful as the Crown prosecutor. So you put all of that together and mix it up. I don't think you can really blame the jury system. The jury system was as much a victim in that trial as was Lindy.
Saxon, in 2015 you were part of a jury trial. You testified that you'd been sexually assaulted. When you first attended court, what do you remember about the jurors?
I wasn't sure if I was allowed to look at them or, you know, while I was telling my story in evidence, it's normal to sort of look towards somebody, and I wasn't sure what I was allowed to do. So it was quite difficult to sort of be who I wanted to be in front of them and try and stick to these rules, and I didn't even know what they were.
Did you notice the gender of the people who were there?
I did take note that there were a few women on the jury, which made me feel a little bit better about the split, that maybe they would sort of understand where I was coming from a bit more.
Did you have a sense of what they thought of you?
I felt a lot of sympathy in the room, especially when I got to really difficult parts of my statement. I did feel like they were really listening to me and maybe even believing me.
Blake, you research jurors. What do we know about how they make decisions?
What we understand is that jurors use stories or narratives to try and evaluate and make sense of the evidence. And these narratives come from their understanding or stereotypes about the world. And they might generate different stories throughout the trial. And they'll select the story that's the best fit for the evidence. And then with that story, they'll find the verdict that's aligned with the narrative.
Could you give us an example of how that might play out?
Well, Saxon was talking about her case, so it's common in those sorts of cases, jurors have to decide whether it's consensual or not. And so there's quite different narratives about consensual sex versus non-consensual sex. And so jurors will evaluate the evidence against those narratives to try and arrive at what's the best fit story for what they've heard at trial.
Saxon, the jury found the defendant guilty of sexual assault. He was given a minimum 3-year sentence. How did you feel about their decision?
It was a really complicated mess of feelings. I felt really relieved that they had believed me. They had listened to everything that I had said and everything that everyone else had said. And, you know, with the sexual assault trial, basically you're saying, this is my story, do you think it's true? And I felt like they had said yes. But I also felt this horrible, horrible guilt that I had ruined somebody's life. You know, this is my story that I decided to tell to the justice system, and somebody else paid for it with a jail sentence.
A jury found the defendant guilty of sexual assault. After 10 months in prison, he appealed, which resulted in a second trial, which was conducted by a judge alone. How did the judge-only trial compare to the jury one, the initial one?
It was just totally different. It was incredibly difficult.
What do you remember about the judgment?
The judge acquitted the defendant and found that even though I might not have consented in my own mind, that the defendant didn't know that.
Lindy, once the jury in your trial went away to deliberate, did you have any idea what their decision might be?
Well, I knew that the judge had summed up for acquittal, but normally if my lawyers explained to me, if a jury has believed the judge, it's going to be quick. But it wasn't quick, it took hours, which meant they weren't agreeing with the judge or with one another. The longer it went on, the more I was conscious that there was a problem. The only place I could get away by myself was the Screws toilet. So I went in there and I was praying about it because obviously I wanted to go home to my kids. And I felt we'd made a good case for that, but obviously something was wrong. And as I was praying, it came to me, I'm not saying the right thing by saying, let me go home. God, you've got your hand over this. It needs to be the other way round. If you know something that needs to be changed for whatever reason, I'll go into prison if you take care of my kids. And immediately I was peaceful and I just knew you're going to prison. I don't know the reason, but God's got one. And that thought had barely passed through my head and the knock on the door, the jury's back. And I knew I was going inside.
When you saw the jury being brought back into the courtroom to give their verdict, what were your impressions?
Almost a hostile feel. Others walked in with their head down, and traditionally, if you're going to get a favourable verdict, they look at you, maybe even give a smile to sort of like it's going to be all right sort of thing. If they don't look at you, you know it's not okay. None of them looked, but 3 of them were crying.
The 12 members of the jury found you guilty of murder. You were given a life sentence with hard labour. How did you feel about the jurors and their decision?
I just felt like they hadn't been peers of the evidence. They didn't understand it. They had no idea.
Yvonne, the media dubbed you the crying juror. What was it like hearing Lindy tell that story?
It's emotional.
Yeah. Does it sort of take you back to the room?
It took me right back to, it took me right back there.
Luana, in 1987, you were living in New York when a French tourist was killed. What did you know about the case?
It was pretty big news in New York at the time. Never in a million years did I think I would be on a jury, but what I knew about it was that he was a French tourist here with his wife celebrating New Year's Eve at a restaurant in Times Square, which is a very, very, very busy place. And as he was exiting the restaurant, I don't want to say the word gang, it was just a lot of teenagers that were, I think the word that they used back then was wilding, where they were just ripping chains off of people and stuff. And he was punched and fell back and hit his head. And that is how he passed away. That's how he died.
So you remember that story, then months later, you realised you were going to be serving on the jury.
Yes.
That must have been a sort of a surprise.
It was, and when they asked how many people, prospective jurors, were familiar with the case, I said, I read the newspaper every day, and I thought that would, not that I was looking to be eliminated, but I thought that would eliminate me, and it doesn't.
2 teenage friends were arrested and charged with the Frenchman's murder. You were selected as a juror for the trial. What were your impressions when you first saw them?
They looked very young. Eric was 19 at the time, David was 16. And David, in particular, had a very, very, very young face. He was petite, and he just looked 12. I was really trying not to let that affect me, because that's not what I'm there for. I was there to, you know, if I was chosen, you're there to weigh the evidence, et cetera. So I was trying not to look at that, but they were being tried as adults. I'm not sure why, but they were. And they were also, it was also 2 defendants being tried at once, which is unusual, I think.
There was conflicting evidence about where the defendants were at the time of the murder. Who did you believe?
I believed the witnesses that placed them at the scene, because there was only one witness that placed them way downtown. And I mean way downtown, almost like the financial district, with which nobody would go to on New Year's Eve. So, and all 12 of us did not believe the one that placed them elsewhere.
By this point, had you made up your mind about their guilt?
The trial went on for 2 weeks. They were very heavy charges. It was hard to get past somebody who was one of their peers, somebody who knew them, to stand in court and say that they were there and that he did it and he saw it.
Once deliberations began, you were the first to vote guilty. Did the other jurors agree?
Well, we were in an oval table and I said guilty, and then the next 7 people said not guilty, not guilty, not guilty. And as they're going around the table, I was somewhere between like shocked and like mortified. I thought, am I going to be, this is going to be an 11-1? It's just like, what did I hear that they didn't? What did they hear that I didn't? I was shocked. And then the last 4 people said guilty. So at least I said, I'm not alone.
So at that point, you ended up 11-1.
We ended up 11-1 after we got everybody's vote. Then we started saying, what's with the not guilty, blah, blah, blah. They said, well, there was only 1 witness. And I said, no, there were 5. There were 4 that placed them there, 1 that... So we went back in. They were very unsure. So I said, let's go back in and hear the testimony. And we did. Then we came back in after hearing the testimony, and it was 11-1.
Only 1 juror held out.
Yes.
Why?
Quote, unquote, I think all cops lie. I can't put someone away that looks like a baby, and the charges are too severe.
What did you feel like the jury's role was at that moment?
To weigh the evidence that was presented to us and that alone. Not how people look. We didn't make the charges up, so if you think they're too heavy, that's not our job. If you don't believe cops, why are you here? I thought that was a legitimate question to her, and everybody got on her case about that, because your question during the voir dire, say I have a problem with his baby face. You know, say I can't do this, I don't believe cops. Not now.
Troy, you were called to jury duty for a drink driving case in Colorado in the US. How did you feel about serving?
For me, I was actually honoured to serve. I've often thought that the jury trial system is a foundation of democracy. I was really proud to serve. Not quite as consequential a case as the ones we've heard so far, but it was important to be honourable in my service.
What was the case about?
So there was a young man who basically came out of his mother's basement. He was living with his mother, and went out onto the street, and he was basically making a lot of noise, and eventually got into a dilapidated car and put it into gear and rolled it down a street. Now, the car wasn't operational necessarily. There was no engine or anything, but he was still accused and was convicted of drunk driving.
Australian jurors aren't allowed to discuss deliberations, but American jurors can after a trial is finished.
Right.
Like Luana, you had 1 juror who disagreed. Did you manage to reach a unanimous decision?
It was 11-1. And the 1 juror that held out just couldn't bring himself to actually convict somebody, thinking that there might be some evidence that he didn't actually hear. So we actually did go in a couple of times. It was a trial where we ended up taking 2 days to reach a decision. And after hearing all the evidence multiple times, he eventually came around. We ended up convicting the defendant on 2 of 3 charges.
Luana, you deliberated for 2 days.
Yes.
What was that time like?
Well, it was 11 to 1 from the get-go, so it was very stressful and very... it got a little rough, and I think in the end...
when you say a little rough, how heated
I
did
remember
it
there
get?
was somebody threw a chair. People always say, well, it's not really like that, like on TV. And I said, well, mine was a little rough. People were getting annoyed. There was yelling. There was, I think she was like cowering in a corner at one point, crying. Maybe there was a little bullying going on. But again, not because, just because it was just so not right of her to be holding us up for that. And we didn't want to be sending out a note, we can't reach a verdict, because I didn't want to put those boys through that again. I didn't, the whole tax dollar thing, no, we got to fix this, we have to do it.
So in the end, she kind of said, okay, I'm with you guys.
Well, very reluctantly.
The jury found both teenagers guilty on all charges. How did you feel when the verdict was given?
I was crying. I think there was men crying. Because even though you think they're guilty, and I felt so horrible for the tourists too, I'm so sorry. I felt bad for the tourists too, but walking in with that verdict, knowing that their future was in our hands like that, it was, I can't even describe how, humbling isn't even the word. It was very sad, sadder than I thought it would be. And one of them started screaming. We never heard from the younger one, but Eric, the older one, said, please, please, I didn't do this, I didn't do this. And that was bringing on more tears. And then they got the shock of their lives. And there was a lot of hysteria in the room.
Blake, you research juries. Jurors are asked to concentrate solely on the evidence presented in court. Is that realistic?
Well, it's certainly true that jurors are influenced by the evidence. It is one of the big things that affects their decisions. But we know jurors are not a blank slate when they're called up for jury service. They're people, and they bring with them their understanding of the world, and that can include biases and stereotypes and mental shortcuts for navigating the world. And these things will influence them as they're evaluating evidence. So perhaps it's not reasonable to expect a juror or anybody to be completely objective and be able to move beyond all of those biases.
Lindy, the media portrayed you as a cold, unemotional person. Why do you think they depicted you that way?
People think that you should react the way they react, and so it depends on your ethnic background, it depends on your personality as much as it depends on how many times you have to go through it. 2 people going through the same event will both have totally different reactions to it because of their personalities.
Anthony, you're a former judge. The Chamberlain's trial was played out in the media spotlight. What role do you think the media played?
It was unrelenting media criticism, painting Lindy in the most unpleasant way. There was no way, I think, that a jury could ignore that, no matter how much the judge told them to put that aside. That's why I say this case was a unique one. The whole of Australia were brought into the media, and it would have impacted most powerfully in the Northern Territory on that jury.
Yvonne, had you heard of Lindy before you were called to serve on her jury?
Definitely, a lot.
What did you make of all those media reports that Lindy was cold and unemotional?
I tended to agree with them at the time. That's how she was portrayed. So that's what everyone was chatting about.
Were you following the news during the trial?
Yes.
So you'd go home each night?
Yep,
switch
it'd
on
be
the
on the news. The family would all ask what happened, you know, friends would ask what happened.
Anthony, are there rules around what external information jurors can access during a trial?
Well, these days there are very strong rules. It's a criminal offence for a juror in some circumstances to access material that's outside the proper processes of the trial, and it's certainly grounds for disqualification of the juror within the trial system. And I think that's a great improvement in the system.
In Lindy's era, would a judge have given directions to the jury about accessing information?
I'm not aware of what directions were actually given, but I'd be surprised if a direction was not given that in general terms said, be careful of what's in the media, but I think the damage was well and truly done. I know my own mother, who's of Celtic background and therefore perhaps not a great example, said to me before the trial, "This woman's guilty." I said, "Mum, how could you possibly know that?" She said, "Well, I've read it in the paper."
There you go.
And that was my own mother.
Can jurors discuss the trial with anyone?
They can discuss the trial amongst themselves while they're in the jury room, of course, but they can't discuss it outside. So they can't go home and discuss it with their family. And that must be very hard.
What happens when it's found that a juror has done their own research?
The Learman trial recently in Australia was a good example, I think, of what happens. It led to the discharge of the jury and effectively aborted the trial and the proceedings, and the case never came to court again. So it had very serious consequences.
Lindy, do you believe the jury in your trial understood all the forensic evidence that was presented?
I actually think they understood very little of the evidence, and the blood evidence was so difficult that our lawyers, Crown lawyers, subsequent lawyers, all actually sat down with scientists, in our case 3 or 4 days, to learn and understand the evidence that was presented and to know even how to ask questions. Now, if the lawyer who has had plenty of previous time to read and absorb, then the jury's just hears it once and it's way over their heads.
Mark, you're a barrister and former New South Wales prosecutor. The Chamberlain case involved complex scientific concepts and forensic evidence. Is it realistic to expect everyday people to understand all of that?
I think that whatever side you're on, whether you're a prosecutor or a defence barrister, one of your roles is to understand the evidence, particularly expert evidence, so fundamentally that you can convey it to a jury in a way that they will understand and remember and be able to act on. There are some areas of evidence that I think are so complex, particularly in financial fraud cases, that you cannot expect jurors to understand them.
What does a conviction of an innocent person do to the system, the reputation of the system?
The saying that we lawyers rely upon is that it's better to have 10 guilty people acquitted, that is found not guilty, than it is to have one innocent person convicted, found guilty. Because if you have an innocent person who's found guilty, it brings the whole system into disrepute. So there are a whole lot of procedures and rules and warnings that are given in a criminal trial to try and avoid a miscarriage of justice where an innocent person is found guilty.
Lindy, after 3 years in prison, you were released after Azaria's jacket was found. A subsequent Royal Commission ruled the forensic evidence at your trial was faulty. Could this have been prevented?
At the time, probably not, because there didn't seem to be any checks and balances to see who did what. People had made up their mind very strongly as to their opinion, and then whether they were really experts or not.
What about the jury system itself in terms of the interpretation of that evidence? Did you feel like a different system potentially could have changed how your trial ended up?
I have thought about that a lot over the years, and where evidence has become more and more complex, like we have today, I've come to the conclusion that instead of the adversarial system that we have in Australia, I would like to see all forensic expert evidence from both sides given to a roving panel of experts, and with all the facilities we've got these days to transfer evidence, look at it online very easily. It wouldn't matter where they came from in the world, but if it's a panel of peers of the particular evidence in each type of evidence to look at it and say, this part of the evidence is questionable or it's rubbish, don't get that near the jury, this we agree on, and of your evidence, that's no good, but this we agree on. Okay, this here is a fact that we can agree on. We put that in front of the jury as a fact, and they don't have to go, what on earth are they talking about? But once you start getting into technical stuff, that's a whole different ballgame, and it should have different rules that allow a person, regardless of whether they've got primary school education and nothing more, or whether they've got a PhD, it brings them all into the same level and they can look at a concrete thing instead of guessing.
Crispin, throughout your career as a journalist, you've covered countless trials. What are some of the flaws of juries?
Well, it's behavioural psychology. People don't like to be on the outer. And in the American case we heard, the one juror who was on the outer was ultimately brought in because it's human nature to not to be wanting to be on the outer. I want to be with everyone else. It's in the nature. And so to say that, oh, we get 12 people all agreeing, therefore it must be good, I don't think that's a very satisfactory way of ensuring you're getting a good decision. And we have all this stuff about, you know, protecting a jury one way or the other way. I just wonder why we have juries at all.
What does that mean for our jury system?
Well, our jury system is very flawed. And if it's not flawed, we can't find out if it's any good because of all the laws that prevent us talking about juries or putting cameras in jury rooms for researchers to look at later on. But we know that there have been a lot of miscarriages of justice, and they come down to jury decisions because the Australian criminal justice system works reasonably well because we have good judges, good defence and prosecution barristers and reasonably good cops, and therefore the system works. But it works well despite juries, not because of them. If we did away with juries and had, say, a judge and a couple of assessors like they do in Europe, I think we'd get better outcomes. Certainly, if you were going to design a criminal justice system today, you would not say, oh, wouldn't it be a good idea to pluck 12 names out of the electoral roll and let them decide? I don't think that's a very rational way of getting a criminal justice system to work.
Saxon, the jury in your sexual assault case found the defendant guilty. He appealed and the retrial was heard by a judge who acquitted him. What did you make of the judge's decision?
With a judge trial, you get to hear exactly why they have found out what they have found out. So in the end, she decided to acquit him, and we got to hear, I think it was 75 pages of why that was. So it was very detailed, and I just felt totally disbelieved. So it was a totally different experience to a jury trial, in that we got a different outcome, but also I got to understand exactly what she thought.
The Crown prosecutor appealed the acquittal. What happened?
The appeals court decided that the judge had erred in her decision, but a third trial was ultimately not ordered because they decided it would be too onerous on the accused for a third trial to stand. So basically I had 2 trials, 2 appeals, and it ended with no legal resolution. And so this idea of, you know, a jury versus a judge, these issues that we have with juries, which is that they come in with their own bias or, have their own ideas. Contrary to popular belief, judges are also people.
Anthony, as a former New South Wales Supreme Court judge, what are your views on judge-only trials?
Well, I'm a great believer in the jury system. I think the jury system has stood the test of time. So I agree with Saxon very strongly. I would put it this way, that if I had to be tried on a serious charge, I was a judge for 13 years, and I know all the judges that I worked with, and I loved most of them very much, and I thought very highly of them for their integrity and their ability to conduct trials and to act as judges. But I would much rather be tried by a jury than any one of them.
Luana, you were one of the jurors who found 2 teenagers guilty of murder and robbery in the late 80s. Both spent more than 20 years in jail, and they both served their full sentences. Years after they were released, you received a phone call. Who was it from?
It was from an attorney who was part of a team of people trying to get all of their charges vacated.
How did you feel when you took that call?
Honestly, I'm not sure that I took it so seriously at first, because so many years had gone by, and I considered it a continuation of my civic duty. I said I will answer whatever I can answer to the best of my ability, my memory, and I'll do whatever I can do. I didn't know if my answers were going to be helping or not helping, but he did mention I was the only juror that they were able to get a hold of.
Did the friend who testified against them change his mind?
He wrote a letter to Eric several years in to say that he was coerced by the police officer and he made the whole thing up.
He made it up?
Yeah. But even then, it took a lot of time and a lot to... They served their full term.
Only a couple of years ago, a judge officially wiped their convictions, acknowledging the original case was flawed with evidence of witness coercion. You were at that hearing. How was it?
Oh, it was very emotional. It was really emotional. Oh, I just felt so sick. I remember the judge said, first of all, if this had happened today, they never would have had those charges. It never would have gone as far as it did, because he said they never should have been arrested, they never should have been tried, and they never should have gone to jail, to prison.
Were you able to speak with them?
I did speak a lot to Eric. I hugged him. I apologized, but he said, it's not your fault. You did what you were supposed to do. I said we did what we were given. We weighed everything with what we were given. And I just couldn't stop apologizing, but they were very gracious and very kind. They didn't seem bitter. It was really amazing.
How has your experience as a juror affected you?
I was very traumatized for a long time after that, to be honest with you. I said, I feel so duped. Like, that police officer lied, and we gave 2 weeks of our lives, and I took it very, very, very seriously. And by the way, the irony of the 11-1 holdout isn't lost on me, because, yeah, isn't it kind of funny? She didn't believe the cop. You know, she thought the charges were ridiculous, which they were. It's not lost on me.
It impacted you emotionally?
Yeah. It still does. I just never forgot their names, never forgot them.
Blake, you're a jury researcher. What do we know about the impact of trials on jurors?
So for a minority of jurors, they do have ongoing trauma as a result of their jury service. A lot of jurors have positive experiences, and that does increase their attitudes about the criminal justice system. But for that minority of jurors, it can be quite difficult to navigate what happens after the trial. Jurors are really only meant to talk to each other about the trial. And once the trial's over, they all go back to their lives, and they generally don't keep in touch. And so the very people they've gone through that experience with will sort of disappear back into their lives, and they don't have that support network anymore.
Lindy, before your trial, did you believe that telling the truth was enough to prove your innocence?
I had always thought that, yes. I thought court was a place to inquire what happened, give all the information, and then the jury could make an informed decision. I didn't realise that it was basically like a game of chess. The best man wins. the lawyers at times would even sit in court, look at one another and go, that's 1 point for me. I actually told my lawyers, if I ever see you do that once, I don't care how good you are, you're out the door, you are not doing that. This is my life, it's not a game.
Yvonne, you were one of 12 jurors who found Lindy guilty of murder. Did you think about her after the trial?
Oh, non-stop. The judge said she was going to do life with hard labour, and that got to me. I just imagined her smashing rocks, how they all used to in the old days, and those words stayed with me, and I couldn't live with her being in jail. But my marriage broke up. That's why it took me a while before I actually came out and said I think I was wrong.
You met Lindy after she was released from prison. How did that meeting go?
Well, I was expecting her to swear at me, but she didn't. She was lovely. She said it wasn't your fault.
You apologised?
I did indeed, yes.
Lindy, how was that meeting for you?
She didn't recognise me, and I turned around, and even then she had to be told it was me. And her first words were, "What have we done to you?" And then I found myself comforting her because she was crying. And I thought, this is not a hard-boiled decision. I was right when I saw her come in and crying over the verdict, that there had been a lot of thought go into it. The whole system can go wrong when you don't understand, and first-time jurors, you don't understand your rights.
6 years after you were wrongly convicted, the courts finally recognised the truth and they cleared your name. Do you think everyone out there believes that?
According to present statistics, a little over 30% still believe I'm guilty. And I found it very interesting myself that after the final inquest, when my name was finally removed as the murderer and a dingo was put as cause of death, I had so many people write and say, finally, it's been proved that you're innocent. And I think that's a problem that we have. Courts in Australia, it's adversarial, where it should be that the Crown is there to assist the judge to find out what's happened, not to automatically say this person's guilty, because in some cases they know jolly well the person is not guilty. The defence is forced to prove you're innocent, and it's not a case of innocent to proven guilty.
You don't often give media interviews these days. Thank you so much for being with us, Lindy. Why is it important for you to be here tonight?
I think that there is a lot that is right about our justice system, but we're all human and we can be persuaded against our will. Trying to get it right and make it easier to get it right, I think is important. And you happen to be talking about the jury system and what we can do to try and get things right. So I said I'd talk to you because that is important. You never want somebody else to go through what you've gone through. You want to try and make that easier. And if we can make that easier, if we can get a groundswell of Australians talking about this to their neighbours, to their friends, to their club, and saying, look, we can do it better, we need to update some things, particularly with forensic. Let's try and make it so we don't make these big mistakes. And I don't think that means a judge on his own, But if you've got people who experience the same thing as you do, and they are told all the truth, not just the bits that suit someone, then we've got a chance of making an informed decision as a jury.
Lindy, thank you so much, and thank you for being with us, and thank you for your company. I'll see you next time.